wakatuambia wamemwachilia. Baadaye wakatuambia wamemwachilia. Tukakaa hatukupata mtoto usiku yote. Kufika asubuhi tukarudi kwa station. Kurudi kwa station tulienda na chai na mandazi. Hatukumpata. Wakatuambia tuende Matunda police station ama tuende tumtafute kwa vituo ya Chang'aa. Hatukumpata. Baadaye mtoto wangu alipatikana Webuye, Ribanzewea Webuye.
Mimi naitwa Safa Niendesia, baba ya marehemu Dennis Lusaba. Marehemu Lusaba amewacha watoto wawili, grade 2, grade 8. Na wote ni wasichana. Vile watasoma, vile watafaa, vile watapata malezi ingine kutoka huko nyuma itakuwa ngumu. Mkiangalia sisi vile tuko, miaka nayo imeenda. Mimi mwenyewe nilizaliwa mwaka 1959. Sasa piga hesabu 59. Na hii watoto wenye niko nayo hii na hii nguvu yenyewe nayo hii taweza hii watoto kweli? Mimi nimeomba serikali vile imeamua uamuzi la leo, siku ya leo. Kwa hii serikali nimeshukuru sana. Na wale wako saa hii masikari mwenye iko hapa kama unajua tu na askari. Chunga binadamu wenzako, baada ya kuchukua mwenzako unaua, na umepewa ulinde. Ni hiyo tu.
Hapa katikati. Mama, hapa you face that with the camera. Yeah, introduce yourself so you can tell us how you have navigated this.
Okay. My name is Janice Moshemi. I work with International Justice Mission, who have been supporting the family of Dennis Lusaba since 2020 when the son was arrested by 2 officers from Bururu Police Post. He was taken to the post where he was handcuffed to the window and tortured to death. It has been a 5-year-long journey for the family seeking justice for the death of their son. However, today the court has passed a verdict in their favor, finding that the police officers should be held accountable for the death of Dennis and to sentence them to 35 years imprisonment. The decision by Justice Nyakundi today marks a landmark judgment in the fight against impunity that is perpetrated by members of the National Police Service. We urge our brothers and sisters from the service that as they're interacting with civilians, that they remember and uphold human rights, and they take into account the plight of the victims. The parents of Dennis have gone through a very tough journey the past 5 years, coming to court listening to evidence of how their son was beaten to death. They have taken up the responsibility of the children that Dennis left behind in their elderly age. And therefore, today we welcome the decision by the court, and we wish to thank the members of the DCI who had the plea of people from Bururu, investigated the matter, and the officers from the Office of Director of Public Prosecution who translated this evidence into the conviction and the justice for the family. Thank you.
Are there other similar cases that you are investigating in the country involving police officers? Maybe you have the statistic, like as we speak now, how many cases are pending that you guys are following in relation to atrocity of police officers, so to speak?
As an organization, we are supporting various victims who have gone through the same journey that the family of Dennis Lusaba have gone through across the country. We have about 50 officers who have been found guilty for the atrocities they have occasioned upon civilians. We have more than 50 cases in court, currently ongoing in various courts within the country, and we hope that the journey to justice for these victims will end in a positive note as that of the family of Dennis Lusaba.
This one is the counselor that has been working with them. You can feel the traumatic side of things.
Yeah, my name is Wilfred Mesocho. I work with the International Justice Mission. I'm the psychologist who has been working this journey with the family. It has been a long journey for the family. We coupled up with the psychological anguish The family have had to come to court for these last 5 years seeking justice. And you see the way the cases take such a long time in court. It also brings the aspect of victim fatigue as they walk through this journey. And what you've seen here today, as the parents get emotional, that is the reality of what so many families go through as they seek for justice. The ones, their sons and their daughters who have been killed in the hands of the officers who are supposed to protect them. So the family had to go through counseling as part of the healing journey, so that even as they come to court, this case, whenever it's adjourned, it's also a trigger for them. So that is why we have worked hand in hand with them, so that even today as the case comes to a conclusion, it also marks a healing journey for the family, so that even as they walk through the next phase of even taking care of the children that have been left behind. So for us is to also give an appreciation to the judge who has been listening to this matter, because even the way he has handled the family and the those ones who have come to give their evidence in his court, it has also been handled in a very sensitive manner, and also validating the feelings and also what the families have gone through. So we, as IJM, we appreciate, and also even for the family, we also want to applaud them for coming to court. There is no single day they have missed court. Even for the many times that the case has been adjourned, they have been present. So that is it from my end. Yeah, we appreciate.
Any question?
We're good. Yeah.
So much because of tireless work following this until we reached this time.
Penalty is one of the sanctions which the court can impose. The guidelines are well settled following the decision by the Supreme Court. In the case of Francis Muratetu, which made the far-reaching what I call the dictum of that particular case, and predominantly the Muratetu case, which was a constitutional interpretation on the issue whether the mandatoriness of the death penalty is still sustainable in our criminal justice regime. And the Apex Court ordained itself and said that the mandatoriness of the death penalty is unconstitutional, but the Kenyan people who gave themselves the new constitution, death penalty remains to be part of our sentencing sanctions for the offense of murder and Section 203. This case falls within that particular spectrum of Section 204, where this court has already pronounced itself on the circumstance of this offense. And what is remained is to answer the question, what is the sentence to be imposed against the two accused persons before this court? I've been able to be provided for with enough robust information on mitigation by the learned counsels for the accused persons, and they have laid quite a number of parameters to do with the mitigation about the accused being first offender, about the accused being remorse, about their age, and about also that fundamentally that a custodial sentence will have far-reaching implications on their rights, as it were. I was also favored with the probation officer's report, what we call a pre-sentence report, which then also captured quite a number of elements within the social inquiry, the personal circumstance of the accused person, the history of this particular case, the family, the victim family was also captured in terms of the requirements of the law. The state also gave pointers on aggravating factors, and with that information, it was left for this court to look at the issues and be able to make a determination on that issue. First and foremost, fundamentally, the Article 26 of the Constitution does protect the right to life. And I consider the right to life to be the ultimate, because it flows from creation itself. That when God created the world, then he said that the world is incomplete without man. And they created man, gave life, we are told, gave life to the first, those who follow that kind of theology. You go to the biblical theology that the first man by the name Adam was then created in the image of God. And that's when people started experiencing. So those who believe in theology follow their creation and their being to the first man in the Garden of Eden. Thereafter there was also the first woman. The book of Genesis tells us that story. That's an historical fact, although it is grounded in the Bible. You come to the legal regime governing this country. We have our constitution, the supreme law of the land, which does protect the right to life. And the same constitution in this preamble says it is for every person, every citizenry to defend this constitution. What does that mean? That when it comes to Article 26, every citizen must defend this constitution by ensuring, guaranteeing that no life shall be lost in his or her hands unlawfully. So it's actually protect and guaranteed. And it's not that provision to protect and guarantee. It's not only the state which must be guaranteed that particular right to life. Is every citizen of Kenya within our neighborhood, within our villages, within our offices, within our homes. We need to ensure that that right to life is protected, is guaranteed within our borders, within our villages, within our offices, that nothing unlawfully shall be done to deprive another citizen or another person within our borders. That's the right to life. The second point of significance is that the sentencing policy guidelines does provide the trial courts with objectives and principles of sentencing in terms of exercising that discretion. What I find that given the trajectory of sentencing in Kenya, it looks like the death penalty is a preserve for the rarest of the cases, and the courts have been able to give various principles, individualizing each sentence according to the circumstances of each case. So what does the sentencing policy guidelines say? They give out guidelines that the issues like deterrence, rehabilitation, reparation, as part of the things they need to look at. It is a mixed grade of some sort, but then the court has to go back and be able to look at which principle, which objective does apply according to the facts of this case. This is a case, without reiterating, going back, where the deceased person seems to have had contact with the accused persons, and the circumstantial evidence seems to reroute itself to the hands and to the contact, to the circumstances of the first and second accused person. In a way, as I made the decision earlier, were involved with the death of the deceased in this case. Apparently so, the court takes judicial notice that the accused persons are a person of responsibility working with the National Police Service, who have been entrusted by the Kenyan people to ensure that they perform their duties, but that trust deals with the security, protection of the law, cognizance of the crime, and that means that in the hands of the police officers of the Republic of Kenya, every Kenyan should be able to feel safe, and every Kenyan should be able to understand that in the hands of any members of the National Police Force, their safety of their property and their lives is guaranteed. There are also, as I said earlier, this was not a matter which the circumstances was able to bring it within the penumbra of self-defense and provocation, as it were, so which meaning that this particular death was never within any of the exceptions, which is envisioned in the Constitution, Article 26, subsection 4, talks about that no one shall be able to take life of another intentionally unless by the given provisions of the law. So this is not one case where any of the exceptions recognized under the law, according to my finding, were able to make that the case falls within that exception. This is an unfortunate incident. As I said in the earlier substantive decision, this is an unfortunate incident, as it were. The other thing, so as I said, the Apex Court, it gives us various parameters on what then goes into that mixed grill for the court to exercise discretion. And that discretion then is informed on those particular main objectives and the principles. So the question in this matter, I looked at, taken as a whole, I haven't seen really true remorse, true regret, which meaning that given the position of responsibilities which our brothers have, there was needed to look at whether independence of this trial, whether there has been true remorse and regret for this offense. There are many ways when you consider about true remorse and regret during the penance of the trial, without that given the position of responsibilities which our brothers have, there was needed to look at whether independence of this trial, whether there has been true remorse and regret for this offense. There are many ways when you consider about true remorse and regret during the pendency of the trial, without necessarily calling it interference or obstructing the course of justice, by just knowing that restorative justice and the victim offender mediation is a powerful tool and is provided for in our sentencing policy guideline, so that there ought to be really through remorse and regret, so that the victim family find healing in situations of this nature. So my view is that cumulatively, putting my thoughts together, cumulatively consulting the law, cumulatively consulting the sentencing policy guideline, cumulatively looking at the submissions on mitigation, my findings are that the aggravating factors in this matter outweigh any metrics of mitigation. When then there is outweighing the metrics of aggravating outweighs the mitigation, that means that the non-custodial sentence is ruled out. Non-custodial sentence ruled out, and the court does exercise discretion, goes with the parameter of deterrence, but mix it with the other objectives insofar as sentence is concerned. And what does that mean? That means that the court does individualize and takes very specifics on how they need to apply the understanding and the precision of the law. What will be the appropriate sentence in this matter? I mentioned about trust. I also talked about breach of duty. And this is really traceable on the whole circumstantial evidence to this matter. Out of the 21 witnesses, the witnesses who were summoned by the state, and also the defense, which was taken into account in overall in this case. My position I take this morning. Yes, our brothers have families. They are breadwinners. They are the ones who support their respective families, as it were. That any sentence of a nature like the one I'm about to pronounce is going to impair the rights which flow from them to their respective families. Was this death avoidable? The answer is yes. Death is avoidable, unless by the act of God. Any death which occurs in the midst, unless the one by the act of God, this is my strong belief that death is avoidable. Particularly, this was avoidable death. It did not have to occur and prematurely terminate the right to life. And as I said earlier, borrowing from the biblical, that every human being from Moyale, Sebania to Witu, he has to be allowed to number his days, or our days are right. And the numbering those days are right. For the one who gave breath, gave the first life to the first man, he said every human being has to number his days, or our days are right to 70. So unless it is proclaimed by the same Creator, then those with is presumed until they controverted that that numbering days are right up to 70 is an actual number in terms of the living, unless again the one who gives and takes it away can start to have said by the act of God. There's also what I call the deaths which occur by accidents, but the deaths which are traceable to the hands of another human being are actually avoidable. Did we have the circumstance that this death could be avoided? The answer is yes. Our brothers had all what it takes to secure the life of the deceased in this matter. But unfortunately, that was never to be, and then we found ourselves in this litigation under the criminal justice system. All in all, I sentenced each accused person to 35 years imprisonment, and they have 14 days right of appeal to the Court of Appeal. They can then test this decision and be able to see whether we exercised our discretion using the legal lens and using the materials and using the principles of the Constitution in arriving at this decision. I thank you so much for your patience, for those who have contributed this far we have come in this litigation. Thank you. I will share this with you, this decision. So I want to go there and share before you leave, and I share with the accused persons. I want to take some few minutes, I share with them. I think that they've started typing these proceedings, operations. There's the DR, so, but I think they've been typing, you know.
How many years ago?
Yeah. 5 years, okay.
So,
kwa majina ni Agnes Ambale. Hii safari ya miaka 5. Hii safari ya miaka 5 tangu ya kifo cha mtoto wangu, nimefurahia kwa haki kupatikana, kwa sababu ya kijana wangu kuuawa akiwa kwa mikono ya maaskari. Baadaye anapatikana Reuben, ambayo imekuwa imenithuru sana katika mawazo, katika magonjwa. Lakini kwa muda wa saa hii nimetulia, nikikuwa kwamba koti ya Eldoret imetoa haki na nimefurahia. Agnes Ambale.
Turudia tu kwa ufupi kama post kidogo tu useme mambo imekuaje, safari imekuaje, na jina lako na ule wako wangapi.
Kwa majina anajulikana kama Agnes Ambale. Hii safari ya miaka 5 itakuwa rahisi kwetu kwa sababu ya kifo cha mtoto wetu Dennis Lusaba, ambao alipatikana kwa mikono ya maaskari. Akakufa akiwa kwa mikono ya maaskari, na baadaye anapatikana Webuye. Imetudhuru sana katika